Good morning. Today is January 16th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday morning, Jean Lawler and I host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. As you know, there's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And since we began this series in the spring of 2020, our audiences have been so generous in contributing to food banks in honor of our great speakers. One of my favorite parts of the webinar each week is when we announce the running total of just how much people have contributed since the series began. Jean Lawler, would you please do the honors?
Good morning, everyone, and Happy New Year, and it's great to be here with you. Yes, the year-end contributions have really raised the amount, and that's fantastic. If you still have some that you haven't let us know about, please do. We'd love to add it to this running total, which, as of today, is $676,521.02, which is that's millions of meals. And so thank you very much.
Fantastic. And today we have a program of particular interest to arbitrators, current developments in arbitration law, presented by our friend David Reif. David is going to present to us a timely and engaging discussion of developments in arbitration law. Dave is the author of a very popular blog on ADR developments. I'm sure he'll give you the link and you can subscribe to it. It's very thorough and witty and informative every week. Attendees today, we're all going to gain insights into recent court decisions that impact the enforcement of arbitral awards, discover how new statutory developments are shaping the arbitration landscape, and explore cutting-edge topics such as class action waivers, online dispute resolution, and the evolving role of international arbitration. By the end of this presentation, participants will have a deeper understanding of the current state of arbitration law and the strategic considerations necessary to navigate a rapidly changing ADR environment. David Reif has been a litigator, changed from trial practice to providing arbitration, mediation, and neutral services several years ago. David was selected as a leader in the field in business litigation by Chambers in 2012, 13, 14, and 15. He was one of the top 10 lawyers in Connecticut and top 100 lawyers in New England for 2013, 14, and 15 in the Super Lawyers Directory, and a selectee by Best Lawyers in America in 2014 and 2015 editions in the field of commercial litigation. I can tell you that Dave is also a tremendous opera aficionado and highly cultured, and it's been a great friend of mine for many years, and I'm delighted that he accepted the invitation to appear on our webinar today. Dave, please tell us, first of all, how people can subscribe to your blog and how they can get timely information on a weekly basis from you. Tell us a little bit about the food bank to which you'd like people to contribute if they're able to do so. And then on with the presentation. The floor is yours.
Sounds good. Jeff, thank you. Thanks to you and Jean and Natalie, not only for the invitation to share some views today, but more importantly for the incredible work working with food banks. I mean, that figure that Jean gave this morning is just astounding. In light of everything that is happening in California, although we have a number of food banks here in the New Haven area, which is where I live, I think it's the Los Angeles Regional Food Bank. Am I correct, Jeff? The one that is basically the major food bank in the area that's been afflicted by the fires.
Okay. And Dave, tell us a bit about your blog and how people can subscribe to that.
Sure. So please, to the extent that you're making a donation, and please do that to the Los Angeles Regional Food Bank. My blog is called ADR Highlights. I've been writing it at this point for about 3 years. It is bi-weekly, as the Irish say, bi-weekly-ish. So some weeks it comes out 3 times. Some weeks it comes out once, driven by a couple of things. One, is there something worth writing about? And two, how is my day job going? The places you can get it are my LinkedIn, just generally LinkedIn. That's one of the places I posted. I've started posting it to Substack. And then the other is it is certainly on a drop down on my website, which is Reif ADR, pretty easy to remember, reifadr.com. So those are the 3 places, Jeff.
Fantastic. And now please treat us to the arbitration law update.
Sure. Let me try to screen share. I go there. Whoops, I lost share somehow. There it is. Share. I'm looking at one participant can share at a time. Can somebody help me out with? I've hit share. That's not what I want to share.
I think if you just click on the share icon rather than the the little.
There we go. Got it. Thank you. There we go. What I wanted to talk about today, my focus, and I think the focus today, just because we need to contain things, is really on what's happening in the federal courts. I'll make some reference, and an awful lot of what we talk about is going to be a carryover elsewhere as well. But let's do our focus on the federal courts. I think there's really, over the past 2 terms, 4 cases that have come out of SCOTUS that I think really drive arbitration. And to the extent that there is a theme, I think the theme is that this Supreme Court, as they do on a lot of other things, tends to read statutes purports to read statutes closely and really look to the language of the statute. And we'll particularly talk about that when we get to one of the Coinbase cases called Coinbase-Bilski, and when we also get to the Smith-Spaziri case. One of the things I'd appreciate as we go along, one of the most valuable things in any of these kinds of presentations is really a chance for somebody to answer questions or try to answer questions that you may have. So I think chat is on. Am I right, Jeff and Jean?
Yes.
And if you have any questions, just throw them into the chat. And then what Jeff will do is take a look at them and pose them at either what's a good time, like right when you give it, or he's got sort of an outline of where I'm going and he can do it at some point later. I think one of the key things to remember anytime that you're looking at an arbitration dispute, and the really very first question is, have the parties agreed to arbitrate? Arbitration is a matter of contract. The scope of it is contract, but even more importantly, the initial question of whether the parties have even agreed to arbitrate is a matter of contract. And the Supreme Court addressed that this term let me see if I can get the page to come down. In Coinbase versus Susky. And what Coinbase versus Susky, and there's a couple of Coinbase cases that we'll talk about, but the Susky case arises out of a contest that took place on the Coinbase platform. Coinbase is a platform, a cryptocurrency exchange platform. Early on, they ran a contest for Doge, D-O-G-E coin, not the governmental Doge, the cryptocurrency Doge. The original, when you signed on to Coinbase, you signed on to terms and conditions that included an arbitration clause. If you if you engaged in the contest, you also agreed to be bound by certain rules. Those rules did not include an arbitration clause. A dispute arose under the contract, under the contest. And the question then became, does that issue have to be arbitrated? It worked its way up to the Supreme Court. And remember, the context is that the terms and conditions for Coinbase had an arbitration clause. Doge did not. And the Supreme Court said the argument was, from Coinbase's point of view, that the arbitration clause in the Coinbase T&C, terms and conditions, carried over to the dispute under the rules. And that therefore, even though the rules didn't have any provision for arbitration, the arbitrator under the terms and conditions had the authority through delegation to decide whether this dispute was arbitrable. Supreme Court said no. What the Supreme Court said is that arbitration is a matter of contract. And what the court has to decide is whether the parties agreed to arbitrate their disputes in the second contract. That all the deference that we give to arbitration under the FAA, all the deference in favor of arbitration under the FAA, does not override the fact that this is a contractual relationship. So Coinbase stands for that. And if you look at any number of cases, both in state and federal arbitration, it reinforces the same thing. For example, the parties can agree to delegate to the arbitrator all kinds of issues. We'll talk a little more about delegation later, but what are called gateway or threshold issues. Scope of arbitration, for example. They can delegate that. What they cannot delegate is what came up under Susky. And that is the question of, did the parties ever enter into an agreement to arbitrate, period? Whatever the scope of that may be, did they enter into an agreement under which they agreed to arbitrate? So that's one of the override, I think one of the major cases to come out of the last term. It sounds like, as you read the briefs, and let me give you a citation to one of what I think is one of the greatest websites out there. It's called scotusblog.com. SCOTUS blog goes back to the days of Tom Goldstein, who was one of the kings of the arbitration bar, kings of the Supreme Court bar. And what they do is they post, if there's a petition for cert, they post everything related to that petition. So for example, all the briefs are there, the petition for cert's there. If you're interested in the state of law, of federal law on anything, subscribe, go on to SCOTUS blog, and best of all, it's free. So one of the other, I would say, crucial cases that the Supreme Court came up with this time is, and the issue that this case and the next one address are stays. So let's think about it from the point of view as a litigator. You bring an action and there is a motion to compel that is denied. What do you do? And the defendant appeals, as they can, a denial of a motion to compel arbitration. And they appeal. What happens to the case during the interim? Can you take depositions? Can you engage in motion practice? Can you try to narrow the scope of the case? What do you do with the witness who may be in extremis? How do you deal with those issues? Coinbase Bilski says you can't, essentially, that once there is a motion to compel arbitration that is appealed, the trial court loses that case. It's gone. They can't deal with any issues that are related to that motion to compel, that would fall within that arbitration. So no discovery, basically no motion practice, nothing. Now as always with lawyers, and particularly in litigation, because as litigators, we tend to be aggressive. The question is, what about? And so what about the witnesses that is in extremis, whom you would need for that arbitration? Let me suggest an approach. There is a provision in the Federal Rules of Appellate Procedure and in the appellate statutes in federal court that allow a federal court to remand an issue to the district court during the pendency of the appeal. Let me suggest that one of your approaches in the event that you have an appeal of a motion, denial of a motion to compel arbitration, is to go to the Court of Appeals. File a motion in the Court of Appeals asking that the case be remanded to the district court under the Court of Appeals jurisdiction for the limited purpose of taking that deposition. That's number one. Number two is move fast. What Bilski says is that once there is an appeal from the denial of a motion to compel arbitration, the district court loses jurisdiction. Why not get everything done? Assuming that you have a sympathetic district court judge or a sympathetic U.S. magistrate judge, why not get the discovery done, try to get as much done as you can before that motion is acted upon? There is a whole bunch of case law out there, too much to really deal with here, that says that the normal standards for a stay are enforced in the district court before a motion to compel arbitration is acted upon. So how important is the issue? What are the comparative risks to the parties if that deposition is taken, if that discovery goes forward? How heavy will the burden be on the one party versus the total, on the defendant versus the total loss of a witness to the plaintiff? So make those motions. So two approaches. The third question that always exists in these is what falls if you have multiple parties and only one party has agreed to arbitrate? What do you do with the other parties? And again, there's a bunch of case law out there that you should look at, but the general trend of the cases seems to be that the case remains alive as to those other parties. And I think those cases are right. The whole concept of that Bilski arises out of is that a court loses jurisdiction over an issue when there is an appeal of that issue, and the Supreme Court's view is that when you appeal arbitration, everything related to that portion of the case that might be arbitrated has moved up on appeal. Well, if one of the parties is not going to be involved in the arbitration, or if the defendant claims that only some of the issues are arbitrable, then the rest of the case under the reasoning of Bilski, I would argue, should remain alive. So what happens? Let's take the other side of that. You are the defendant, and there is an appeal, and you file a motion to compel arbitration. And that motion is granted. Now, remember what the appeal rules are under the Federal Arbitration Act. You can appeal from the denial of a motion to compel arbitration. You cannot appeal from the granting of a motion to compel arbitration. So if I'm the plaintiff and there is a motion to compel arbitration that is granted as to me, And I want to be able to challenge that before we go through the whole arbitration. What do I want to do? The strategy up until this year under FCIArb has been to ask the court not to stay the case, but which is what the Federal Arbitration Act provides, but rather to use its judicial discretion and dismiss the case without prejudice. So what does that mean? Under the normal rules of federal civil procedure, or under the statute, there is an appeal from a final judgment. If the case is dismissed, I then have a final judgment. If I'm the plaintiff, I could appeal from that. No more. In what I think is a unanimous case, which Bilski was not, then what I think is a unanimous case, if I recall correctly, FCIArb says no. The Federal Arbitration Act says that if a court grants a motion to compel arbitration, it shall stay that the litigation pending the resolution. So it does not have that normal discretion. So what happens if a motion to compel arbitration is granted? Suck it up. You're going to arbitrate. It's that simple. And so then move on to your arbitration and push all those issues. And whatever challenges you had to whether you entered into an agreement to arbitrate, whether the arbitrator, whether certain things could be delegated to the arbitrator, the scope of that arbitration, all those issues, you're going to have to raise those later. It increases the cost, it increases the inconvenience of the parties, it increases, I would argue, the burden on the court, but that's what the current state of the law is. So what else have we had come up this time? Let me go to Badgero while we're talking about litigation issues. Badgero was decided in the 2021-22 term, but it's really, I think, one of the most important cases that probably have come down in the last, I'd say the last decade. Under the Federal Arbitration Act, let's talk federal court jurisdiction. And we all know that there's got to be jurisdiction, and as my contracts professor put it, or civil procedure professor put it way back in the day. He used to like to use Latin. Ex nihilo nihil fit. Out of nothing comes nothing. And so if a court does not have jurisdiction, it can't do anything. So the question then becomes, does the district court have jurisdiction to do what you're asking it to do? We all remember from our federal civil procedure case that if there is not diversity jurisdiction, one of the things that you look to is federal question jurisdiction. Under the Federal Arbitration Act, if you file an application to compel arbitration, the court can, and the underlying arbitration has to do with a federal question. We won't bother to flesh out what that means, but it has to do with a federal question. Then you can look through the application and decide whether, and if there is a federal question, have federal question jurisdiction. So what's the implication of this? If I don't have diversity jurisdiction, I don't have all parties on the opposite sides of the V. I don't have $75,000 in dispute. I don't have diversity jurisdiction, and but for federal jurisdiction, the district court wouldn't have jurisdiction, couldn't hear my motion to compel. The issue in Badgero is, does the same rule apply if I'm moving to confirm or vacate an award? So the award has now been issued. We're no longer we're no longer in court. We're outside of court, and I now want to move to confirm or vacate that award. Can I use federal look-through jurisdiction if I don't have diversity to get the court to have the jurisdiction to do that? The flat answer under Badgerow is no. And they base it, I think appropriately, on a difference in language between the motion to compel arbitration, the section that deals with vacating or confirming. The section that deals with compelling specifically talks about look-through. The other section does not, and under the good old rubric that if one part of a statute talks about something and allows something and the other part doesn't, then the presumption is that the legislature did not intend to allow you to do that in the second case. Badgerow, while very important, may have a little bit more limited jurisdiction than it used to, or value than it used to. Why? Because of Spazeri. You no longer have a situation where a court dismisses the case, because of Bilski and Spazeri. You no longer have a situation where the court dismisses the case. The court now retains that case. So you have, the court still has jurisdiction to vacate or confirm, even if its initial jurisdiction was under federal question. Put a big flag next to that statement I just made, because what I've told you is what a lot of the cases say. There are cases out there that disagree with that. So as litigators, if you've got somebody, if you're defending, or you're moving to confirm, or you're vacating, take a look at that case law very closely if you do not have a diversity jurisdiction, because there are cases on both sides of that issue. You need to see what the law is in your district. You need to see what the law is in your circuit. What this also means, though, is that you are going to get a lot more action in state courts on vacating and confirming arbitration awards. Because if the federal court can't do it, then you're going to want to go to state court. So a couple of things on that. One, unfortunately, you're going to get a lot less uniformity in case law regarding arbitration and arbitration procedure. And that's a problem. I mean, the whole concept of the Federal Arbitration Act was to try to bring some uniformity to how arbitrations are dealt with. So practice tip, if you have a sense up front that you may need to vacate or confirm, and you have only federal court, only a federal question, you don't have diversity, think about where you want to seek that arbitration. I mean, that's not something you're going to think about in a $75,000 arbitration, because it's going to cost you more to think about it than the value of that issue. But if you're dealing with a big arbitration, spend the time to make that reasoned decision. So that's number one. Number two, if you are interested in arbitration policy and you're working with your state bar association on arbitration policy, ask them, and I guess this is a personal view, flag, ask them to push for the revised uniform law of arbitration, because that then establishes a standard that is going to be followed in most of the states, and so we'll get some of that uniformity back. Predictability for corporate clients and for those who are litigators. Predictability is one of the most important things that you want to have. And Badgero has reduced some of that predictability. And I think as lawyers, we need to try to find a way to get that back. Let me back up to a case that addresses an issue that is one of the burgeoning issues in commerce, and that's the last mile question. Amazon, DoorDash, are different kinds of last mile delivery systems. Amazon, it's the guy who picks up the product at the warehouse and drives it to you, who may or may not be an independent contractor, and who puts it at your front door. DoorDash, it's the guy who picks up, or woman who picks up the food at the delivery at the restaurant and brings it to you. Uber, it's the Uber driver. And in the case of Bisonet, it is the person who stocks bread on the stands at your local grocery store. These people are involved in the stream of commerce in one way or another, and the Federal Arbitration Act does not cover seamen, railway workers, or, and this isn't a direct quote, but it's accurate, interstate transportation workers who are involved in interstate commerce. What the heck does that mean? If the Uber driver is picking up a product that has moved through interstate commerce, as almost all of those brown boxes that show up every day on my front steps are, but picks that up in-state and delivers it in-state, is he or she a worker in interstate commerce? Because if they are, then the federal court cannot enforce that arbitration agreement that essentially exists in all of their contracts. What about the person who stocks the shelves? And that's what Bisonet is about. Bisonet says, reverse the Second Circuit. The Second Circuit had said that what you look to is the nature of the business for whom that person is a contractor or by whom he or she is employed. So in other words, LePage Bakery, which is a bread delivery question, bread, cookies, those kinds of things, getting them from the warehouse to the shelf. Second Circuit said, hey, look, the person at the grocery store who orders that to be delivered, the bodega, the supermarket, whomever, is not buying a delivery service. He or she is buying bread. And therefore, the delivery person is not a worker engaged in interstate commerce. The worker is a bread delivery person. Supreme Court says no. Supreme Court says, and they base this on a case that Southwest Airlines versus Saxon that you can go look at, which involved a person who worked for Southwest Airlines as a ramp supervisor and would sometimes load your suitcase on to the flight to Dallas, that person was a worker in interstate commerce. Now remember, the employer, the airline, is already in interstate commerce. But what Bisonet says, per the Supreme Court, unanimous decision, I think, that bread delivery person is in interstate commerce because what he or she is doing is delivering a product in interstate commerce. So what did the Supreme Court do? They did what they always did. They say, we're reversing it, figure it out. And they sent it back to the Second Circuit. This case actually came out of my home district, the District of Connecticut. Sent it back to the Second Circuit. And Second Circuit on December of last 2024, so a little over 4 weeks ago. Sent it back to the district court with a number of questions that the district court needs to consider. There's several of them. These cases are not necessarily of broad interest. They affect people who represent either delivery type people or people for whom deliveries are made. So I won't go into detail on all the buys in that case. But if you want to know what one court thinks you need to consider in making that decision, take a look at the 2024 US App Lexis site that's on the slide. So let's look at some, since we've talked about those cases, let's look at some of the issues that are out there. One of them is the question of what's called manifest disregard. Now let's turn to the Federal Arbitration Act, and that act lays out specific bases, numbers them, on which an arbitration may be vacated. None of those include what is called manifest disregard. Way back when, 2008, it's amazing that this issue is still kicking around 16 years later. And 16 years, by the way, being the last time my Pittsburgh Steelers got themselves very far into the playoffs. Said that the grounds in the FAA are the only grounds for vacating an arbitration. The context of the case, the parties, Hall Street and Mattel, had put together an agreement that said that the district court, on an appeal from an arbitration award, could consider whether the arbitrator was right or wrong on the merits. Supreme Court said no. Supreme Court said Section 10 tells you what they can do. Well, let's think about that. The words manifest disregard do not appear in that laundry list of bases for vacating an arbitration. So where does that leave us? Well, believe it or not, there is still a circuit split on the issue. And I think that the split, the last time I looked, was that the Sixth Circuit says there, and the 11th Circuit say that there is no such thing as a reversal for manifest disregard. Second Circuit says, oh, yes, there is. Fourth Circuit says there, yes, there is. And I think it's the Sixth Circuit that says, nah. They really haven't decided one way or the other. So one of the questions you've got, and one of the things you may want to look at in the big case, when you decide where you want to seat your arbitration, is whether you can get a reversal for manifest disregard. Now, to a certain extent, manifest disregard arguments are angels on the head of a pin, because your chances of getting something reversed for manifest disregard are about the same as the chances of my Steelers getting into the playoffs next year. They are minimal. What is the general test for manifest disregard? It is that the legal issue was clear. So in other words, that means that the cases tell us that there is no question regarding the principle that the highest authority within the state that would decide that issue, that legal issue, has decided it, and has decided it definitively with no way around it. Two, that law was called to the attention of the arbitrator, because the arbitrator has to have known about that principle, because look at the words. If I don't know about it, I can't disregard it. So those are the two. Three, that the arbitrator basically intentionally disregarded that law and said, here's what the law is. The law is clear. I'm not following it. So your chances, whether you're in a circuit or not, that recognizes manifest disregard, your chances of getting that is a reversal, but it's there. And as we know, as litigators, you're going to win some arguments that you shouldn't win, or at least you don't think you're going to win. So look at that. Interestingly, as I said, it has been 16 years since Hall Street came down, and the parties have been fighting about it, and the academics have been writing about it ever since. Supreme Court seems to have no interest in resolving the circuit split. I can think of at least two situations where they've had petitions for cert, where the question presented has been, does manifest disregard still exist? And they have not taken them. So let me just talk about some other things. One is the question of international discovery. The New York Convention governs treaties signed by essentially everybody, including, unlike a lot of treaties, the US, deals with arbitrations before international tribunals and the enforceability of those in treaty countries. So in other words, if there's an arbitration in Denmark, and I'm hoping that that's a treaty country, if there's an arbitration in France, because I know that's a treaty country, and that is confirmed in France, what can the US do in terms of confirming that? So that's what the New York Convention is about. But one of the issues under US law is that US law provides for, in Section 28, in other words, the discovery, the federal statute related to civil procedure, provides that there is discovery in the US in connection with its use in a foreign tribunal. That's the word, tribunal. And the hot issue for a long time was, okay, if I've got an arbitration in France and there is evidence that I want in the US, documentary evidence, a crucial witness, can I get the US court to issue a subpoena for me to be able to get that information, to use it back in France on the other side of the pond? What that hinges on is a commercial arbitration panel a tribunal? ZF Automotive, which was a case decided back in 2024 by the Supreme Court, I think unsurprisingly to most scholars, although there certainly were policy reasons that go the other way, said no, that a foreign tribunal is a governmental body that is deciding a dispute, either civil or criminal. There is some judicial gloss that's come down since then. What happens with bodies that are convened under a treaty? What happens with bodies that are convened under ICSID? Are those foreign tribunals, since they're not actually the government itself? And those cases go both ways. If you're in the situation, and where you would be in the situation probably is not that you're in the foreign arbitration. Where you really would be in this situation is if you represent somebody domestically and you get that ex parte subpoena and you want to go in to quash the subpoena, that's where the issue will come up. So bottom line is that if you're a commercial litigator, you need to know the issues there. You need to be able to go out to ZF. You need to go read ZF Automotive. And walking out of this meeting today, you probably don't need to know much else. Status of arbitrator conflicts. I haven't done the research on it, although I tried then, but able to find it. I don't know what percentage of vacatures are granted in federal and state court because of a purported arbitrator conflict. I do know that in international arbitrations, that is really a significant issue. I don't want to use the term fast and loose, but the rules on disclosure of conflicts in the international realm tend to be a lot less strict than I think we US arbitrators, domestic arbitrators, would consider appropriate. And there have been some real problems that have come out of some of that, particularly with a major arbitration in the United Kingdom. Internationally, those rules are being looked at. And while you may not be an international arbitrator, it's interesting to take a look at it. The International Bar Association has put together, back in 2014, put together guidelines for conflicts in international arbitration. And they sort of have a bunch of traffic lights. They have red lights, green lights, and orange lights. Red lights are issues that are absolutely a conflict. There are waivable red lights, but you at least have to disclose the existence of a red light conflict and give the parties a chance, in some cases, to waive it, in some cases they can't. There are orange lights, which means slow down and take a look, as opposed to my view of yellow lights, which is hurry up and get through them. Orange lights, which mean slow down and take a look, you probably need to disclose this. There are green lights, which say this is not something that's disclosable. Excuse me. Those were just amended late last year, and they're worth taking a read at. And the biggest changes were that in terms of large international firms, I mean, I wasn't even a large firm. When I retired, I was in a 415 lawyer firm. I had a bunch of partners I'd never met. And so the old red light was, if your firm had ever done any work for a client, for one of the parties, that was a red light. You couldn't take the matter. They've now provided that if you yourself didn't have anything to do with the matter, I mean, think about DLA Piper, which is well north of 1,000 lawyers. If you never had anything to do, it now is a red light. You need to give the parties can waive it, but you have to disclose it. The other deals with experts. If under the old rules, if an expert had testified before you in a previous arbitration, that was an orange light. It's now a green light, but it still says look at the orange light. The key thing to remember is these are international arbitration. They are guidelines. They are not strict rules, and they probably don't apply here domestically. I can tell you that the AAA's rules, for example, are a whole lot more stringent, and the guidelines of the College of Commercial Arbitrators are a whole lot more stringent than anything that's in those IBA guidelines. For example, if you have if an expert has appeared before you before, or you've served on the same panel with an arbitrator before, that's disclosable here in the US. And I will repeat the rubric that it is far better to disclose something and lose the appointment than it is to have somebody pick up Westlaw, see your name, and see that an arbitration's been vacated because you never disclose a conflict. It's risk management. There are a lot of cases out there. We all live and die by appointments. Appointments are important to us, but the quickest way to kill appointments is to get a bad reputation, and the quickest way to do that is to have a bad published case. AI. When I was talking to Jeff before this, he said to me, you cannot do a presentation, you cannot do any discussion these days without mentioning Taylor Swift and AI. I don't know from Taylor Swift. I'm a generation removed. I know that she had that the Eras tour was the largest ever. I mean, it's like the budget of the budget of a small nation. But let me say just a couple things about it. One, AI is not going to put arbitrators out of business. AI is going to put arbitrators who don't understand AI out of business. So it's important that all of us understand AI, what it will do for us, what it will do for us, and also what its risks are. I mean, remember, AI runs off is trained, and it's trained on a base. So that means that the more things you post on AI, the more things you ask AI to do, two risks. One, you risk privacy. Arbitrations are private, they are not confidential. That's an important thing to remember, but they are private. So you're risking that privacy. Two, you are risking bias. And I don't mean intentional bias, but what goes into the AI and what the AI uses, what the AI goes into the AI is going to skew what the AI puts out, garbage in, garbage out, info in, skewed info out. And that's not something you're going to know. Secondly, be aware of all the risks and be aware of the governing rules. AAA has what they call, I think they call principles that lay out what the arbitrator has to do. I mean, the arbitrator has to be transparent. The arbitrator has to be sure that he or she has covered whatever they're going to cover. The arbitrator has to let the parties know specifically what they're doing with specifically what they're using AI for. So you're going to want to take a look at those. Also, for those in who are doing IP disputes, Silicon Valley Arbitration and Mediation Center, which is probably at the risk of maybe making some of the boards I sit on, tribunals I sit with upset, is probably the primary IP arbitration group in the country. And certainly one of the thought leaders. They have specific issues related, specific guidelines out there for using AI. Finally, it's interesting, there are now, for the first time, a set of rules specifically addressing AI disputes. James recently, I think since last summer, I know it's no further back than that, has issued a set of rules for what they call artificial intelligence disputes, not regarding the use of AI, but regarding ownership and those kinds of things. Other than that, I think that's what I've got. I will close with a couple of things. One, being an arbitrator is one of the most interesting things out there. Arbitration is very different from mediation, but it encompasses it. My recommendation to arbitrators is that when you come up with procedural issues, act as if you're a mediator. Try to work out a dispute between the parties as to whether a scope of evidence comes in, whether a subpoena, what subpoenas go out. See if you can resolve that by mediation. It moves it along a lot more quickly and makes it a lot cheaper. What you want to be arbitrating and what you want to be deciding are the substantive issues. On those, the core issue is be fair, disclose, and rule in a timely fashion, because that's what the parties are paying you to do. Jeff, Jean, that's it. If there's any questions from anybody, we've got 5 minutes, and as I say, I think that's probably the most valuable part of any presentation.
Dave, that's terrific. Very comprehensive and very insightful. Thank you so much. If people have questions, please post them in the chat and we'll take a look and read them out to Dave. Let me ask you a question, Dave. In the recent past, what's the toughest call you've had to make as an arbitrator? Don't disclose any confidential information.
No.
But generally speaking, what's an example of a tough call?
I think one of the consistent tough call, and it's happening more and more now, is that there are, as in litigation, there are more and more pro se parties now. And the really tough issue that I find that I face is where there is a pro se party, how much can or should I do to make sure that that party understands what they're doing? Because part of fairness is making sure that all parties are fully advised without cutting over the line, which has to be a Maginot line, an absolute chasm of not giving that party any legal advice. Because the time that I do that, I'm overstepping my role as a fact finder and a law decider, and I'm prejudicing the other party. So, I mean, while that's not a substantive issue, I think just consistently, and that shows up a lot now in consumer cases. So I think that's probably the biggest.
Also, there's a question in the chat about the distinction you drew between confidentiality and privacy. Can you elaborate on that a little?
Sure. Privacy is that nobody else is privy to what is going on in connection with the proceeding. Confidentiality is that no one ever finds out the result. And here's the difference. I mean, let me pose you a hypothetical. An award is rendered. It is in an arbitration that the parties deem to be confidential. One party moves to vacate that award, or the other party or the other party moves to confirm it. The court needs to consider that award in order to reach that decision, its decision on whether to confirm or vacate. The award, the court needs to be able to see that award. That award, the rubric and the law is that whatever a court considers is public, if it is crucial to the court's decision. And the case law, I think probably without exception, is that the court will deny a motion to seal the award if it's basing its decision on that award. Now, a caveat in what you may be able to do is the parties can agree that parts of the award that are not relevant to that decision can be sealed. So, for example, if the issue is, did the issue fall within the scope of the arbitration clause? And the arbitrator said yes and granted an award of X dollars. A court may well let you seal what that X dollars was. But they are not going to let you seal the fact that that one of the parties won and what the arbitrator said about why it's relevant. So that's where I draw the difference between privacy and confidentiality.
Dave Reif, this was a terrific presentation, comprehensive and thoughtful. As I said, thank you so much. If people are in a position to help support a food bank, you've recommended either the Branford Food Pantry in Connecticut, where you live, or very graciously, you've also recommended the Los Angeles Regional Food Bank here in Los Angeles, where we're suffering the deadly fires are still going on. They're not completely under control yet. And we just pray that they will be under control and that no further lives or property will be lost.
And Jeff, again, thanks to you and Jean and Natalie for the incredible support of food banks over the years. Every day they serve an important purpose in taking care of those who otherwise would be in a food desert and unable to afford to support themselves.
Yeah. You're welcome. We thank you so much, intern. Another wonderful presentation, Dave Reif. And with that, we are complete.
Have a great day, everybody.
Thank you.
Thank you.
Dave, before you go, someone had asked me